A viewer recently accused me of taking big money from Mackenzie Shirilla's family to cover this case. Let me be clear, I haven't received a single dime, but what I did find are the active federal habeas corpus documents showing how Mackenzie's original legal team completely botched her defense. Today, we are tuning out the internet tantrums and looking strictly at the legal strategy because honestly, this federal petition reads like a blueprint for a brand new trial. Welcome back to the Notorious.tv, your home for all things scandalous, eccentric, and over the top. If you've seen the Crash documentary on Netflix, you already know how deeply divided people are over the Mackenzie Shirilla case. If you're new here, Mackenzie Shirilla is currently serving 15 years to life for a 2022 collision that killed her boyfriend Dominic Russo and passenger Davion Flanagan. Prosecutors claim that their toxic relationship drove Mackenzie into a calculated rage where she intentionally slammed her Toyota Camry into a brick building at 100 miles per hour. Judge Nancy Margaret Russo agreed during her bench trial, and Mackenzie was sent straight to prison. I've broken down the black box forensics in previous videos, so definitely check those out, and don't forget to subscribe to the channel for more deep dives. But now that you're all caught up, today we are going to go over what exactly a writ of habeas corpus is. Then we'll discuss the key grounds and claims in Mackenzie's federal filing. Next, I'll give my theory on the reason why her first attorney felled her, and then we're gonna go straight into the conversation that most of y'all are not ready for, which is why a new trial is extremely likely. We'll talk about how a jury trial will change things and which outcomes are legally possible. Then we'll wrap by discussing what Mackenzie's post-release life would look like. And I've got to just say real quick that this video is for educational purposes only. What's discussed here are my opinions, and those opinions are based on readily available public information. So, with that said, let's talk about it. A writ of habeas corpus is one of the most misunderstood tools in the justice system, but it's a critical constitutional safeguard. In Latin, it literally means, "you shall have the body." Habeas corpus is a mechanism that forces the government to bring a detained individual before a federal judge to prove that it has the legal constitutional authority to keep them in prison. Habeas corpus is not about relitigating the case or deciding whether someone is a good or bad person. It's really just about examining whether the legal machinery that put the person in custody was fundamentally broken. It evaluates whether the constitutional rights of the accused were violated during the process. So now that the federal petition is officially filed, the state will submit its formal response to the Shirilla's 8 grounds for relief. And then the defense will have a chance to reply to the state's reply. From there, a federal judge will then review the complete record to determine if constitutional violations warrant vacating Mackenzie's conviction or ordering a new trial. This review takes time, but the legal wheels are officially turning. So now let's break down the key grounds and claims in Mackenzie's federal habeas filing. If you're still here, you are more committed than most of my exes. So make it official and subscribe to the channel. It's a free way that you can show support and help the Notorious.tv grow. First, the filing points out an issue that took place before the trial began, which is an improper juvenile to adult bindover. Because Mackenzie was 17 years old at the time of the July 2022 collision, and I'm talking 48 hours away from her 18th birthday, but her defense argues that transferring her case from juvenile court to face trial as an adult violated her due process rights. In Ohio, anyone under the age of 18 is legally a juvenile. And because Mackenzie was 17 years and 363 days old at the time of the crash, her case legally had to start in juvenile court. For the state of Ohio to move her to adult court, they had to go through this high-stakes process called a mandatory bindover. So that's what the filing is talking about. Under Ohio law, a 16 or 17-year-old defendant who's charged with murder must be transferred to adult court, but only if the state can definitively prove probable cause that the teen acted with purposeful intent. So during the juvenile bindover hearing, the judge dismissed the aggravated murder charge due to a lack of probable cause regarding prior calculation and design. However, the court did find probable cause to bind over the charges for felony murder, felonious assault, and aggravated vehicular homicide. The habeas filing specifically challenges the probable cause for purposeful or knowing intent required for those remaining charges. So the next points have to do with actual trial errors, the first being ineffective assistance of trial counsel. The filing states that Mackenzie's original trial attorney failed to present critical exculpatory evidence. This included an alleged medical diagnosis of postural orthostatic tachycardia syndrome, also known as POTS, which can cause sudden blackouts. And there's a lot of controversy out there as to whether or not Mackenzie actually had POTS, as it's my understanding that POTS typically causes blackouts whenever someone goes from a sitting to a standing position, which wouldn't be the case for someone sitting in a car driving like Mackenzie was. But we can pretty much predict that the defense is going to claim that medical factors could contribute to a loss of consciousness regardless of position. And I honestly think that it's possible Mackenzie was maybe misdiagnosed with POTS, because we do know that she had blackout episodes because it is discussed multiple times in her text messages that everybody's reading. Nonetheless, a lot of people make the argument of, why was she even driving if they all knew that she was prone to blackouts? In a potential future jury trial, that detail alone could really be a significant factor for deliberation. Now, Mackenzie's counsel also failed to present text messages regarding her boyfriend's past steering wheel interference. And there's a whole lot of online chatter and arguing behind this situation. And if you want me to do a full breakdown on that situation, please let me know in the comments. But Mackenzie's attorney also dropped the ball by failing to present an explanation that Mackenzie was driving in the area the morning of the crash to pick up groceries. So basically, she had a reason to be in the area, which to my understanding is corroborated by text messages between Mackenzie and the grocer, who would leave produce in lockers for customers to pick up. So this evidence combats the theory that she had scoped out the route in advance and took the road for the purpose of orchestrating this crash. And that detail I find is repeated so much by people on the internet who believe that the crash was intentional. They say, her phone pinged in the area. She went 3 times to scope out the route she was going to take, and she planned this all in advance. But even Dom's sister, Christine Russo, she loathes Mackenzie with every fiber of her being, but even she doesn't go for that. Like, she has said in multiple interviews that she thinks that Mackenzie just snapped into a sudden rage, and that's what led to this crash. The next point in Mackenzie's habeas corpus filing is ineffective assistance of appellate counsel. The appeal process is designed to look at the official court transcript and find any errors that may have happened during the trial. Like, for example, one could be that the judge should not have been shown this particular photo. Of course, I'm just making this up. This is just hypothetical. But that's the type of thing that can be argued in an appeal. You can't introduce any new evidence at this stage, but Mackenzie's team argues that the attorney handling her initial direct appeal failed to raise key constitutional issues to the higher court. So basically, they didn't adequately challenge the trial court's underlying legal errors. The habeas corpus filing also argues that Mackenzie was failed by her post-conviction counsel, as they missed a strict 365-day statutory deadline to file her state petition for post-conviction relief. Now, a request for post-conviction relief is where you can present new evidence that's not found in the official trial record, and her legal team failed to account for 2024 being a leap year, missing the deadline by 1 day. And so that caused the state courts to dismiss the case without even evaluating its merit. So up until now, honestly, I've never really considered that this would be a piece of the habeas corpus filing. I didn't realize that, it points to ineffective counsel. But in hindsight, I'm like, well, of course it does. Like, get it together, attorneys. Come on now. It shouldn't be held against her that her lawyers waited until the very last minute to file for post-conviction relief, and then it gets denied on a leap year technicality. However, it's a key requirement that you have to exhaust all the state resources first before you can do a federal habeas corpus filing. And I point this out really because post-trial relief is typically decided by the original trial court. So we could compare this to like how corporate HR departments investigate employee complaints made against the same company that pays them. I mean, you know the drill. They investigate themselves and find no policy violations. So you can kind of see how the original court's review could potentially present a bias because they'd have to take a critical look at their own work and admit if their original findings were ultimately wrong. And we all know how big egos can be in the legal system. And since the federal government doesn't work for the state, a habeas corpus filing acts as not only a safety net, but a review of constitutional compliance. So this is the juncture where Mackenzie's case sits right now. And the next point made in the habeas corpus filing is the insufficient evidence of intent. Mackenzie and her legal team say that the state failed to prove beyond a reasonable doubt that Shirilla acted with purpose or knowledge to cause the fatal crash. The defense argues the prosecution lacked adequate evidence of criminal intent for a murder conviction. And I talk in depth about the crash forensics and black box data in my other videos. If you haven't seen those, definitely go check them out when you're done here. But if you have watched my other videos, you know that I actually agree with this because intent, in my opinion, is actually objectively impossible to prove in this case. And the presumption of innocence is supposed to fall on the defendant. And I don't know if Mackenzie is innocent or guilty. I've said this multiple times, but whether you like it or not, this is what US law states. So don't come for me, even though I know a lot of you just can't resist. Take it to that keyboard, do your research. I've literally done my research. How do you think that I come up with a 30-minute script? But let's move on to the improper modification of the coroner's report, which I must say is a very fair point in my opinion. Originally, the coroner's report listed the deaths of the two victims as accidental. However, at some point before the trial, the prosecution met with the coroner's office and they presented their belief that the crash was intentional, and they urged the coroners to change the report to say that the deaths were a result of homicide. And I think this detail is extremely important because even though the coroner is not a judge, not a jury, the report was changed. And Mackenzie's legal team says that this directly prejudiced Judge Nancy Margaret Russo's ruling because it created a presumption of murder before the trial even began. And I totally agree with that because why would you change it to homicide before the verdict was even in? That's a major screw up in my opinion. So to everyone who gets upset when Mackenzie Shirilla gets a new trial, go yell at the prosecution because their sloppy mistakes helped pave the way for this habeas filing. And the habeas filing also points out the violation of the Sixth Amendment confrontation clause. The state actually introduced autopsy testimony and findings through a medical examiner who didn't actually perform the autopsy on the victims. So the defense contends that this violated Mackenzie's constitutional right to confront the witnesses against her. And I mean, here we have another fair point. Like, why didn't they just put the correct medical examiner on the stand? Like, I think even Stevie Wonder could have seen this objection coming. I mean, when you see everything laid out, the legal reality is impossible to ignore. And I'll be honest, I just do not think the internet is ready for this conversation. But guys, I think that Mackenzie Shirilla is gonna get a new trial. If the judge looks at this, how can they look past all of these objective legal standards that make some really great points about the flawed process of this trial? The ineffective counsel is definitely a strong argument, but then look at the biased coroner's report and the Sixth Amendment right violation. These are all very compelling regardless of whether you hate Mackenzie or not, because the hate is irrelevant. But it seems so many people are incapable of pushing past that and just separating their feelings from what's actually happening. This trial violated the fundamental due process that every American is entitled to. And honestly, we should all be thankful that these safeguards exist because they exist for a very good reason. Now, as promised, I have a theory about why Mackenzie's attorney did not defend her properly, and it actually came from a viewer comment on one of my shorts. He told me in a pretty rude way that Mackenzie's attorney did this as a strategic move, and at first, I thought that was a pretty wild take, throwing a trial on purpose, because that's literal legal malpractice. But then I flashed back to one of Steve Shirilla's interviews where he said that right after the guilty verdict, the attorney walked up to them and straight up said, you can just blame it on me.
He didn't do anything for her. In fact, at the end of this trial, he told me to throw him under the bus.
And Steve Shirilla also mentioned that the attorney said that the judge was not buying the medical stuff.
You talked to him and said, "Where's the pot stuff?" What did he say?
He said this is his words. He didn't even turn it in. He told us after one of the dates that the judge is not buying it. That was his word. The judge is not buying it. That she has a diagnosis. That was his description to me.
And once you connect those dots, a completely different, almost sinister psychological theory starts to make a lot of sense. I think that in the beginning, this attorney's ego took over and he pushed for a bench trial because he thought genuinely that he was the mastermind that could convince a single judge that proving intent was objectively impossible. He envisioned a quick, black and white, no-brainer acquittal. But then something changed. Mid-trial, he realizes that Judge Russo is completely locked into the prosecution's narrative, and he realizes that he just walked his client into a massive trap by waiving her right to a jury. So if you want to get really conspiratorial here, put on your tinfoil hat. Because did he have the epiphany that his only move left to save Mackenzie from his own mistake was to just stop trying? Because that's what happened. Did he intentionally underperform and leave out the Potts defense to guarantee a slam dunk appeal down the road? Now look, legally speaking, I have to say this, it's just a theory. No lawyer is ever going to openly admit to throwing a murder trial just to force a do-over. But when a defense lawyer tells a grieving family, "Oh, it's fine, just blame it on me," it makes you wonder if the incompetence that we saw in that courtroom wasn't just carelessness, but a desperate last-ditch exit strategy. So I think we can pretty much all expect that if Mackenzie gets a new trial, she's gonna roll the dice with a jury this time. And a jury trial is a completely different universe. I mean, juries struggle with proving invisible intent. Juries compromise. They often hunt for middle ground charges like vehicular manslaughter instead of throwing someone away for murder. And it only takes one juror, to look at the evidence and conclude that the state did not prove murder beyond a reasonable doubt. I mean, at the very least, we could be looking at a mistrial that prolongs this process even further. But to put this into perspective, I want to share a few fascinating comments that I've collected from you guys that show how everyday people look at the car data completely differently than a judge does. First, one viewer shared a terrifying story about how their slipper physically got stuck under the gas pedal, flooring the car and causing a total loss of control. They said that they do not wear slip-on shoes when they drive any longer. Totally understandable. Another viewer commented that they finally understood why they had a situation where they accidentally rammed their own car straight into their garage wall because of an unintended acceleration glitch in their Toyota. And third, this one is huge. A viewer wrote in saying that their husband fainted behind the wheel and that his entire body went completely stiff and that he floored the vehicle. And this isn't just an internet rumor. It's a heavily documented medical fact in fainting while driving cases. When people black out, they don't always just go limp. Their muscles can seize and go completely rigid. And that completely negates Christine Russo's assertion on her podcast that if Mackenzie had fainted, she would have just gone limp and left the pedal unaffected. So now ask yourself this. What if someone, just one person, on a new jury has lived through a terrifying situation just like one of these? And if they have, they will not see this crash the same way that Judge Russo did. And the crazy part that nobody wants to admit is that people online right now are saying, well, the judge found her guilty, so she's guilty. And those are the exact same people who are suddenly going to not trust the justice system if a future jury disagrees and acquits her. Their entire appeal to authority logic is going to collapse the second that the authority changes. A jury trial does not, of course, guarantee an acquittal, but it absolutely resets the entire dynamic. So now let's look at the actual legal outcomes that are possible if a federal judge grants Mackenzie Shirilla a new trial. The first possibility, of course, is a full acquittal. If a new defense team brings in medical experts to testify about POTS, syncope, sudden drop in blood pressure, and fainting physiology, a jury could easily determine that the state failed to rule out a medical collapse. And if they can't prove what was happening in her mind, It's textbook reasonable doubt. And the second possibility is a compromise verdict on lesser charges. In Ohio, juries are not forced into an all or nothing choice between murder and walking free. So the charges could be downgraded to reckless homicide, which is a third-degree felony, carrying 9 to 36 months per count. And they could also look at aggravated vehicular homicide, which carries anywhere from 2 to 8 years, along with a lifetime driver's license suspension. And they could also look at involuntary manslaughter, which is a first-degree felony carrying 3 to 11 years per count if tied to an underlying felony. And you may remember there were drugs found in the car after the crash, so that's likely going to work against Mackenzie. And when you factor in that Judge Russo originally ran Mackenzie's life sentences concurrently, the math changes completely. And I broke down in my previous video how the judge's leniency in this area kind of goes to show the judge's own internal conflicts. So go watch that video next if you haven't seen it yet. But as for this federal filing, a conviction on any of these lower tier felony charges completely resets her timeline, especially since Mackenzie has already served several years in jail, so she'll have credit for time served under her belt. I mean, it could mean the difference between her spending her life behind bars versus walking out with a clear near future release date. And who knows, will she get parole before that even? So while no one can predict with certainty how a future jury will weigh the crash data, my personal take is that a life sentence for murder is the least likely outcome if this gets retried. Hate to disappoint you guys, because I know I see a lot of people in the comments, not even just on my videos, but other videos on the internet, they'll say, oh, well, she'll get convicted of murder again. Like, this is totally a no-brainer. Like, you know, I'm not even worried about it. Of course, they're going to send this little demon to prison for the rest of her life. But I just really think that that's the least likely scenario here when all things are weighed and considered. Even if Mackenzie doesn't walk away with a full acquittal, the defense having the chance to present this full context with new experts, it just makes a lesser charge compromise far more likely. And here's the kicker that most people completely overlook, that Mackenzie doesn't even have to go through a second trial to get out of her life sentence. Because if she wins this federal habeas corpus appeal, the state's murder conviction is erased and a plea deal is instantly back on the table. So prosecutors might be terrified of facing a new defense team armed with POTS medical experts and text messages about passenger steering wheel interference. It's highly likely that the state would offer Mackenzie a downgraded plea to aggravated vehicular homicide just to guarantee some prison time. And Mackenzie could take the deal, count her time she's already served, and walk out of court with a guaranteed release date in her near or distant future. And this is the part that nobody thinks about, that if Mackenzie is ever released, she will be legally free but socially condemned. She's gonna live the Casey Anthony life, like permanent suspicion, permanent surveillance, and permanent commentary. Every move she makes is gonna be dissected online. Employment is going to be nearly impossible. Relationships will be probably pretty complicated as well, and she's never going to truly, completely escape this narrative. Honestly, Mackenzie's situation would be far more intense than Casey Anthony's because she's a Gen Z defendant in a Gen Z internet ecosystem. Casey Anthony walked out of jail in 2011 when social media was still pretty much on training wheels. There was no TikTok, no Reels, no algorithmic dogpiling, no 24/7 commentary economy. Casey Anthony had the opportunity to kind of just slip away into the Florida humidity. And if you guys remember about that case, she ended up being taken in by someone on her defense team who realized, like, okay, so if she gets acquitted, where is she even gonna go? Because by this point, she's like burned the bridges with her family. And yeah, where would she even be safe? Everyone in America was talking about it at the time. So like, I think her safety would have been in jeopardy, like if she just went and rented an apartment somewhere. And plus, like we said, like employment would be so hard. And Casey Anthony, from what I understand, does paralegal work for the guy who took her in, and she kind of just like became part of their family. Very weird situation. I wonder what Mackenzie thinks about as far as like her plan when she's released. Like, where's she gonna live? If she's off paper, is she gonna flee the state of Ohio? I would certainly hope so. But yeah, it's just a crazy thing to think about. Every move Mackenzie makes is gonna be screen recorded, reposted, stitched, duetted, slowed down, zoomed in. Even if she wins legally, she won't win socially. She'll be living in a digital prison without bars, built by a generation that documents everything and forgets nothing. So yeah, this case really isn't closed. And if her habeas corpus petition succeeds, we're about to watch one of the most controversial retrials that the country has ever seen. The outcome, whatever it is, will not change the minds of the people who decided that Mackenzie Shirilla was guilty before the trial even started. But it will change the legal reality. And at the end of the day, that's what actually matters. So let me know in the comments, do you think that Mackenzie's gonna get a new trial? But that's gonna be all for now. I will see you guys in the next breakdown.